Anybody have copies?
We've got copies. We are, Perfect. In Senate Judiciary, it is February 13th. We have S 45, not to be mistaken with S 44. Agricultural bill from Senator Douglas. And yeah, please feel free to give us a general introduction, and then we'll hear from Ledge Council to provide some of the more specific details.
Wonderful. Thank you. Good morning to all the fellow senators here. So yeah, S45, this is the right to farm bill. This was first, it was originally introduced back in 2021, and it was a lot different than how it is now, because it was introduced in 2021, went through Senate Judiciary already, and they marked it up pretty significantly. It looks a lot different from the original version. In my opinion, it's a lot better once it got marked up. So what it does in a very broad overview, and Mike Grady, again, we'll talk about this a lot more, is it just provides civil litigation protection for farmers when they are operating in a normal fashion. If right now in Vermont, we have a lot of issues with people moving in, and that's great, but they move in and then will complain about the smell of the farm that's next door that they moved in next to. And a lot of those farmers are worried about getting sued because Vermont has among the worst or the weakest right to farm laws in the country. So, the general thinking is that you as a farmer should not get sued if you're just running your farm. As long as you're operating in a normal capacity in a normal fashion as every other farmer does for your type of farm, and if you're not the way what about adding a remark about in Senate Judiciary last time is not violating the state's water quality requirements as well. So if you're not dumping manure into the rivers and you're operating your farm in a normal fashion, then you shouldn't get sued. It is the general thinking, because you're just operating your farm. So that's the big piece about it. And it gives farmers a lot more peace of mind in operating their farms. So a lot of farmers right now do feel like they're walking on eggshells. One farm up in my district, they get complaints filed against them all the time by their neighbors that moved in, and they just don't like the smell of manure. And every time they spray on their fields that border their house, they put in complaints or they get phone calls. And the farmer is just, it feels like walking on eggshells because you don't know if you're going to get a lawsuit at some point. You don't know if some of the spray from their manure is going to hit the wind and then go over. Well, farmers can't control the wind, and you should be able to spray on your own farm. So that it just gives a lot more peace of mind, and it really brings Vermont into parity with the rest of the country that have a lot stronger right to farm laws, including New York, which is right next door to us. The other part of it is the mediation clause. So if a farmer is operating in a way that is not normal, commonly accepted agricultural practices, or they're in violation of state water quality requirements, then before bringing a suit, you have to at least once make an attempt to go through the state mediation process, which is already laid out in the statute. And really what this does is it makes this issue between neighbor to neighbor instead of having to bring it to a courtroom. And I think that really aligns with Vermont's philosophy of community and bringing it down to a neighbor to neighbor basis instead of having it in that courtroom. It saves a lot of legal fees for everybody involved, especially farmers. A lot of farmers are they don't operate paycheck to paycheck. They operate loan to loan, bank loan to bank loan, just trying to continue the operation of the farm, hopefully pass on to their kids. So a lot of firms do not have the money lying around to pay for attorney's fees for doing to fight a lawsuit. So by having to go through mediation first, if a farmer made an accident or something and they would be liable to be sued and didn't have the protections as Bill gave, you have to go through mediation first. So it really protects the farmers in a second way, especially if an accident happened. And I think that's very useful because it protects the farmers from getting hit with a lawsuit that they're not going to be able to pay for. So it really just keeps them from bankruptcy. And right now we have an issue with farms that are closing year to year, and you can see that in the data very clearly. So, Senator Baruch.
So I'm looking at page 4, lines 11 through 13. If I'm reading it right, this is kind of the heart of the bill.
Yeah.
In other words, all things being equal, anything that fits under this definition is immunized, from lawsuit. So,
That and the water quality
Yeah.
requirements. Yes, sir.
Yeah. but practices conducted in a manner consistent with proper and accepted customs and standards followed by similar operators. So it's obviously meant to be broad and protect across the board. Who would determine that other than a judge at the end of the day? Is there any other guidance by what proper and accepted customs and standards would be?
So this was part of what was added during markup in Senate Judiciary last time. This line wasn't in there originally. And it's, I would say no. I think a judge would be the final determinant of what is, but I think it's also pretty obvious what is not going to be generally accepted agricultural practice. If a farmer is spraying manure in his fields, that is generally accepted agricultural practice. That is how all farms operate in the state of Vermont. So it is very broad, and that's intentional, but it's also very clear cut. If every farm is operating in the same manner, it's very easy to tell who's not.
Well, but I guess there could be, you can see how there would be immediate differences of opinion, like somebody's trucking manure around their property and they're dropping a lot of it on the road and the neighbors get angry about that.
Mhm.
The farmer could say, well, this is just standard practice, right? But the neighbor could say, but dropping it on the road isn't standard practice, moving it with the truck is. So you have a dispute. And that's, I guess, what mediation is designed to resolve
Yeah,
in as many situations as possible.
yeah, for sure. And when it comes to dropping manure on the road, I mean, up where I'm from, and I'm sure Addison County, Franklin County would agree with me. That is generally accepted practice, dropping a little bit on the road here and there.
Well,
But making sure that you have your load secured is generally accepted agriculture practice. So if you're dropping significant amounts, then yeah, there's a big difference there.
Yeah.
If I can interject, typically, it's been a while since I've looked at negligence torts, but as best as I can remember, that looks relatively similar to the language when you are trying to compare whether or not a professional has deviated from the standard care that they are expected to practice. And I can't remember the language off the top of my head, but it's looking at whether or not the acts are deviate from the norm of another professional in the same field and in good standing. And so I can see how that language somewhat mirrors what is expected when, or what's contained within the negligence case law.
Mhm.
But yeah, it's something that would be looked at either by a judge or a jury. Please continue.
I really think that's all I really have to say on it. Again, it brings Vermont to parity with much of the country for right to farm laws, gives farmers peace of mind, and hopefully will keep farms from having to be under the burden of lawsuits, settlements, or how to pay out attorney's fees. I think right now the only people, a lot of the only people that be against this is civil litigators that want to get some nice attorney's fees. So, but I think that's what it is.
Committee, any further questions for Senator Douglas? That's great. Thank you. You're awesome.
Thank you.
I have the council coming in about 5 minutes. Adam, did you want to get 5 minutes?
Yeah, about that much time.
Okay. And I wanted you to come in based on, we had our schedule change a lot, but Vermont trial attorneys, I think it'd be good to get some perspective there.
Yeah.
And then we'll also have ledge counsel and
Very much
a better understanding. But yes, please.
Okay, thank you, Mr. Chair, members of the committee, Adam the Group, Vermont Association for Justice, the plaintiff's injury bar. Let me start with a few key high notes. We're here to like help your understanding of the issue. This is not an issue that we've been actively involved in with this journey over the last several years. We're very loyal to the Judiciary Committee's involvement with tort law. We'll be back on, we appreciate the auto insurance and premises liability is percolating in the air. So I want to be very clear. This is not an area where civil litigators are seeing everyday business. And I'm in here somehow protecting like the legal buyer's interest. I'm really just counseling on, we have the benefit of tracking so many issues in this building. And so I was able to, when I got a note from the chair, pull up all the hearing notes I have on this from previous years. And so let me just populate the air with a little bit of straight talk about it, but be very, very clear. We don't have kind of like political energy into this. You will get that from the environmental community, and they are the ones and their lawyers who have been involved, because it's a lot more about pollution than people being harmed. You know, our involvement with on-farm activity is sometimes you get into legislation around agritourism. And so we immediately go to the unsecure railing in the not oft used wedding barn where grandma leans against it and falls, and we get into kind of discussing that with you. So first, let me befuddle the idea we're here to kind of feather some nest. But start with kind of points of observation. Tort law is very confusing, and it's the common law. It came from, England on the boat, and it's the largest consumer protection that occurs out there every day between citizens. It's the compact we all have to not act carelessly and hurt other people. This legislature is generally not wading into that because we have these 12-member juries that are relatively conservative, and in the world of American juries, we're the most conservative and the hardest to succeed for a plaintiff. So that's kind of the authorizing part. This law was, this proposal is brought forward after there's a lot of articles about this dispute between a large dairy and neighbors. First point of observation, all the way back in the common law, you cannot come to a nuisance and then sue and complain about it. So you can't move in next to a farm that's operating and then complain about the odor and noise. You can go to a lawyer and maybe bring that forward as a suit. It's going to be kind of rejected on summary judgment. You're not going to get to a trial. What's provocative about this bill, the current law is a rebuttable, if you follow these practices, you get a rebuttable presumption, meaning the burden shifts to the plaintiff, that you are not creating a nuisance. This proposal jumps to, if you follow these practices as a matter of law, you can't be questions of creating a nuisance, but goes further. And so this is where I would red flag a little bit of the margins on this trespass law. Trespass is, and this is what this lawsuit you're going to hear a bunch about, because the lawyers from both sides are going to come in here vigorously. We're not involved with them. Trespass is the intentional act of entering someone else's property without permission. It's a civil tort that violates the owner's property rights. And so this is a little different than like you're making noise or I can smell your manure. This is your pollution is coming onto my property and impacting my property rights. It's a physical difference. And so you're going to see three grades in that, three steps in this. Well, how's this rebuttable presumption working? Do we want to close the courthouse door to this happening at all, being questioned at all? And then if we do we want to do it for nuisance, or do we want to go all the way and do it for trespass? My notes that I pulled up from last year, you'll hear a lot about the case that motivated this several years ago. The neighbor won that case, and the farm was recently found in contempt of court for failure to comply with the order. The bill substantial limits property rights by extending right to farm to trespass, not just nuisance.
I'm just having a hard time imagining what is the trespass specifically? Something from the farm is trespassing.
Yeah, I've got these ditches on the side of my fields.
Yeah.
Where when I spread the manure, the water, like it's it's hard on the lake, but it's how it works. You know, it's dairy's a high impact thing on water pollution. That ditch is finding its way into my water supply.
I see.
So
So,
like the pollution's literally coming onto my property.
and that goes under trespass rather than some other,
Well, in this legal dispute, that's kind of where that came in. That's like, I came into your house at night. Like I physically came into your house, not, you know, I shined a light and annoyed you or something.
yeah.
With the, what is a farm is the other thing they're going to get into. And again, I'm just trying to be a narrator for you folks. This is probably the last you'll see of us on this issue, but you're going to have vigorous on both sides of this. You know, what is a farm? Well, we encourage value add, right? Like we really wish that we could add more value. You know, dairy to the co-op and on the global supply isn't as good as making cheese, make it whatever. But I know there's a whiskey relabeler that's on a farm, and you know, you get into hours of operation, trucks idling at 4 a.m. You know, well, that was different than, you know, when the farm was traditional farming. And so, you know, Michael Grady and Ledge Council are phenomenal experts on all this. I didn't see you come. You have very knowledgeable counsel here. I'm a bit of a placeholder, just providing you a bridge to your council. And so, you know, having said all that,
Yeah. Well, yeah, thank you. I think, since we have, Michael Grady here, I think that, I figured have you fill some time, before you showed up and want to hear your thoughts initially.
okay.
Yeah, thank you for coming in on very short notice. Next up, we can hear from Ledge Council, which I think will be a bit more of a decent meeting for us. Yes.
So this is Mike O'Grady with the Senate Council. I've been working on right to farm bills for 10 years, maybe more. And a couple of years ago, I was hearing testimony from many advocates saying that Vermont's right to farm bill was weak or one of the weakest or the model for the weakest. And so I went and I did a 50-state survey of all the right to farm statutes in the country. And every state has a right. Even DC has a right. And I think the characterization of Vermont's law as weak or are being on the less protective side of the spectrum is probably accurate. Because when you look at some of the other, I'm going to read to you provisions from 3 different states. I'm going to read to you from Kentucky, Michigan, and my favorite, New York. Oregon, okay, thank you. So it says this is Kentucky, no agricultural, silviculture operation or any of its appurtenances shall be or become a nuisance or trespass, private or public, or be in violation of any zoning ordinance if they were in operation for 1 year and they are complying with good agricultural or silvicultural practices. No nuisance or trespass. They have to be in place for 1 year and they're complying with good agricultural practices. Well, then you go to Michigan. They have 2 ways you qualify for nuisance protection. You're not a public or private nuisance if you are conforming with generally accepted agricultural management practices, just like Kentucky, right? And there's no 1 year limitation here in Michigan. Just if you are complying with those practices, you qualify. Then you qualify for the protection if within 1 mile of the boundary of your land, there is no change in use of occupancy, et cetera, and you were not a nuisance before the adjoining use came in. That's what Adam was referring to as the coming to the nuisance doctrine. So that's another way. And then Oregon. I love this. And no farming or forest practice, so their law just applies to forestry as well. On land zoned for farm or forest shall give rise to any private right of action or claim for relief based on nuisance. So they just need to be zoned. And they are free from any nuisance or trespass. Except they kill someone or seriously injure someone or damage a commercial agricultural product. That's the only time you can bring a nuisance or trespass claim against a farm or forestry operation in Oregon. So you're gonna hurt someone or you're gonna hurt somebody else's crop. That's it.
Sarah, let's get.
Is it that you're going to or that you have?
That you have.
Okay.
And
Yes.
there was a situation, it was a forestry situation, there was a large forestry operation up there. A forestry, a cutting harvesting firm was spraying its stands for pest infestation with a helicopter. The helicopter flew over a neighborhood, sprayed the neighborhood. No nuisance, no trespass.
Wow,
That's each.
that's intense.
So that is the level of strength that other states are providing in their right to farm or right to forestry laws. It is not conditional, or it's very, there's minor conditions that attach in order to qualify for this protection. And then you have to compare that to Vermont, and in S45, you see the current standard in Vermont on page 4 going on to page 5, where it's struck through, where an agricultural activity is entitled to a rebuttable presumption. So it's not no nuisance claim. You have a rebuttable presumption. And what that means is somebody can sue you for a nuisance, but the court will presume that you are not if you meet these following factors. It's conducted in conformity with federal, state, and local law. It is consistent with good agricultural practices. It is established prior to surrounding non-agricultural activities, and it has not significantly changed since the commencement of the prior surrounding non-agricultural activity. So you have to show 4 things before you even get a rebuttable presumption that you are not a nuisance. And then that presumption can be rebutted on page 5, lines 5 through 8, by showing that the agricultural activity does not constitute, by showing that the activity has a substantial adverse effect on health, safety, or welfare, or has a noxious and significant interference with the use and enjoyment of the neighboring property. So Adam was saying, oh, if you have a coming to the nuisance, the court's not going to find that coming to the nuisance. That's not the case. If you can show that it has a noxious and significant interference with your use and enjoyment, or it has an adverse effect on health, safety, or welfare, you can rebut that, and then you show that, and then you show how your property was adversely affected by the farm. You could get an award in the nuisance claim in that situation. Now compare and contrast that to Kentucky and Michigan and Oregon and Louisiana. The list is pretty long on the strong side of it. And you'll see why Vermont is characterized as on the less strong side. And so what S45 is doing is trying to strengthen that right to farm protection from nuisance and trespass, as Adam said, and to more align with those states that have the strong right to farm protection.
I'm pretty clear on nuisance. I'm just wondering about trespass. So trespass, if I'm reading the way it's being applied here is some material from my farm is making its way onto your property.
Yeah.
That to me doesn't seem like good agricultural practice, right? Because
So let's use the situation, the case that Adam was referring to. It wasn't manure that was coming off of the property and crossing property boundaries. It was drained water from subsurface tile drains. Do you know how subsurface tile drains are? That is a good practice. That is, they had worked with UVM and the UVM extension expert on subsurface tile drainage to put in drains to manage their fields so their field wouldn't be as wet, so they could use it for cropping, so they could apply nutrients and manure on it without that greater risk of it flowing off of that property. But what it did is it increased the flow in the stream for the subsurface tile drainage. And that flow increased as it crossed the property boundary and scoured out the field in the neighbor's field. Got it. And there is, you kind of were intuitively like, isn't there some other law that governs this? There's a whole body of common law about upstream water users, downstream water users, and how, but the court referenced some of that and kind of used it to support her claim of trespass. But it was Judge Mary Teachout, that's what I'm saying. And what she said is it's a trespass. They increased something from their property and it damaged, they did it intentionally and it damaged the neighboring property, and that was trespass. And there was no protection for trespass. There is no protection for agricultural trespass. And it does happen, whether or not it's your livestock or your custom applicators applying manure on your fields and his wagon breaks and the wagon turns over and all of that flows across your neighbor's property. These are actual things that have happened. And so that would be trespass. So it does happen. In other states, that would be protected. You can bring that action.
it kind of reminds me of, and maybe it's a similar thing to Clemens, but the laws about railroads, protecting railroads. And then I remember there was, from my one legal history class in college, I remember there was a case that said the ruling was let the quiet citizen keep out of the way of the exuberantly active one. The railroad, just keep out of the way of the railroad, basically. And in this case, if we were to change it so that we got rid of trespass and nuisance, we would in effect be saying we're preferring the activity of the farm. If it scours out your field, it's kind of hard line for you.
Well, it's interesting that you say you're preferring the activity of the farm, because you actually say you prefer the activity of the farm in statute right now, the purpose section for the right to farm, where it said it is the purpose of this chapter to protect reasonable agricultural activities conducted on the farm from nuisance lawsuits.
Right, and I guess, that's where I come down to that page 4 piece.
Right.
Where it says practices conducted in a manner consistent with proper and accepted customs and standards followed by similar operators. It is putting forward a standard. I just don't know enough about the area to know what is included or excluded there.
Right, and that is a standard used in other states. And you're right, it is not defined in many other states. It's defined in some, but it's defined based on what their actual rules or regulations are. And so that you can't really do a one-for-one transfer. But in other states, it's not, and it becomes a fact-specific issue in the litigation. You bring your experts, I bring my experts, we determine what's good, customary practices and what it's not. And you would have that, say, for the case that was discussed, was the subsurface tile drainage that a good practice? Maybe, but the way it was implemented, maybe not. And so then that becomes something that the court has to make her decision.
Or here first, the mediation.
Or right here, yes, because one of the things in this bill is that prior to any person filing for nuisance against a farm, that they have to go to mediation first. And that was something that was developed in either the last anyone before in the agriculture committee to try and bridge some of the criticism of what was being proposed, because as Adam referenced, the environmental advocates will likely not support this bill. One of their large or significant part of their argument is it's not necessary because there are really not that many of these lawsuits that occur. And with the one that occurred recently, well, they would have been in violation anyway because it was trespass. It wasn't nuisance. They also violated some environmental laws. Yeah, there was a sort of additional evidence in that case, but that case has really created significant anxiety in the farming community because they were working with UVM. They did what UVM said. Yeah, they might have messed up with some wetlands, and yeah, maybe their field was not the best, but they were trying.
Senator,
So I have a couple questions. Are there mediators available to do this mandatory mediation, and who bears the cost of that?
Well, that's a good question. That there is a mediation community that would be available. I think it would be reasonably easy to find it. And then I'm sure there were some people, especially in the more agriculturally developed areas, who would create a practice around that. And I don't believe it specifies they shall, but they agree to submit the issue to binding arbitration. They share costs, but I don't think cost is in there on the mediation itself. It's a good question.
And Adam had said that, and I, based on your explanation, I don't know that the truth, it sort of alluded to the fact that this would bar certain things from going to court.
So that's a kind of a common presumption or, but you can sue and you can file your claim. It's just that the court will say they're entitled to protection. So it's not that you can't sue, it's just that the court has a standard it has to follow in these type of actions. So if you were an attorney and someone came to you and said, I would bring this, the attorney has to advise you, it's likely on the set of facts that the court will dismiss. So it doesn't bar them, but it leads to the same result.
So then the point you made about the different experts would never have a day in court to sort of like prove those fact patterns. Is it good practice? Is it so?
Well, maybe. Remember, it all depends on what criteria you're going to use. Say if you're Oregon, there's no experts in Oregon. It's just banned. But here, whether or not you qualify is let me go. It's so if you are engaging in generally accepted agricultural practices, and that is defined on page 4, where you are complying with a permit or the RAPs, you're complying with the pesticide rule, and you're either implementing practices conducted in, that's all fact specific.
Okay,
So you will have potentially a court will say, and under this, suppose Oregon, all right, we have some facts
okay,
that we need to determine. If I'm the farmer's attorney, I'm gonna move for summary judgment right away. I'm gonna say this, we need to dismiss, the facts are clear, this is all. You know, I haven't had a violation of my RAPs and my permit. I haven't used pesticides, or I'm a certified applicator and compliance. And I'm doing everything I'm doing is good practices. Now, the court's gonna probably say, well, I need to look at the facts of that, but
Okay.
I would move for summary judgment, right?
okay, that's helpful. And then my other questions are sort of around and this is just because I don't know agricultural law, but do we have a definition of what is a farm and what is agricultural activity?
Yeah, so, and it's, there's a general definition with regard to general regulation of farming, and then there are specific definitions in this bill. So there is a definition that's referenced in two definitions. One is farming is defined under Act 50. And that's livestock raising, production of crops, maple syrup, on-farm energy production, and a couple of other things, raising of 3 or more horses. And then the definition of agricultural activities in 6 BSA 4802 is pretty specific. Use of equipment, types of equipment, things of that nature.
Now, if I'm doing those activities as well as other things, does it apply to anything happening on the farm, or only does my question, like if I'm doing those things, but also, I don't know, I can't even think of something else, but
I mean, that goes to Adam's point, is like, what is a farm? And, or what is farming? And you really have to look at that list.
okay,
Because it might include, you don't have to do like, I'm not a robot on your iPad.
sometimes.
I'm not a robot.
Well, and I guess I'm happy to take a look at the list, but I guess my question is, if I'm doing the things on the list, but something else I'm doing on the property is a nuisance, is that protected because it's happening on a farm?
No, it's the activity that is protected. It is not the farm that is protected.
Okay.
So
And are there any, and this was, I'm gonna probably make you dig up the same thing you were already just digging up with this next question. Are there any, as we define a farm, are there any restrictions about where it, like, and I'm thinking of a specific instance that I probably talked to you about when I was in the house about cannabis and some ducks in Essex. In the middle, like across the street from the high school, in the middle of a doubt, like, is that a farm? Are they like?
So the way that the regulatory authority of the agency of ag is triggered over farming is if you trigger what are called threshold levels of the RAPs, or required agricultural practices. And that means you have a certain number of livestock. So there's a list of Noah's Ark lists. If you have like 5 or more cows, or 100 or more chickens, then you are farming. And one of the ways that you can qualify other than livestock is that you're producing $2,000 or more in income from the sale of agricultural products from your property. And so duck eggs are pretty expensive, and you could probably make $2,000 or more of the sale of those on your property.
Even if I live on a quarter of an acre across the street from the high school with neighbors on all 4 sides.
And I believe the Agency of Agriculture did say that the property was farmed.
maybe we can get the agency of ag to come in and we could add them to the witness list for
Steve Collier is testified on that. He's their general counsel.
I have a question for Senator Adams, actually. Are somebody's buying a property, is there a required disclosure that they're buying a property that's adjacent to a farm?
Not usually. I always make it a point because like showing property, Milton up in Franklin County.
Yeah.
You're more than likely going to be near a farm in some areas. And I always make it a point to let clients know that there's a farm in the vicinity, and depending on what time of the year it is, there may be smells and activities, whatnot.
Yeah.
So they know up front.
Yeah, it may be helpful, to explore that as an idea of making a, somebody's buying a property that's adjacent to a farm, making a required disclosure that, let's just say hypothetically, if this bill passed, that the liability or lack of liability applies to that farm, and the person purchasing the property could encounter a variety of things, such as things that you just described.
Depending if it's a material defect of the property. Would it change somebody's money, basically?
Yeah, I want to respond to your thing, but I'm assuming when Senator Bruce was referring to the practice conducted in a manner consistent with proper and above, that the court is never looking at what's reasonable and prudent. They're going to use that.
Right, or what the industry standard is. Let's think about manure, and you need, in Vermont, you need what's called a nutrient management plan to qualify for protection under the water quality laws. So if you're applying your manure under what's called a 590 plan, that's pretty much standard. Everybody knows that's standard. That's good practice, right? If you're doing it under your own self-made nutrient management plan, we might not want to call that a best practice. That might be something we would have to look at how you actually did that. Determine what your land application rates are going to be. That's going to be something that a court would have to take testimony on and look at the facts of how this person developed their own nutrient management plan. 590, that's national. Everybody does 590. Your own like little tailored back of the box nutrient management plan, yes, probably not going to be great.
And my second question is looking at, because this appears that it could be a civil suit, is that why we are using the preponderance of evidence versus as a low standard of?
Yes. It is not the higher standard. It's 50. Right.
Okay, thank you. And just quickly I understand where you're going to that. It's going to be tough because in the county that I come from, we have what's referred to as over the road farmers. So someone could buy a piece of property and then not even knowing, Chris could say that on a daily basis, anytime between April 15th and December 15th, manure trucks are coming down through here, so they may roadways and whatever else, and just something to consider in reference to that.
Yeah.
There's over the road farming going on here. So
Yeah, I just think I get what you're saying. I think some disclosure, if we even contemplate that as an idea, could be helpful. More so for the farmer, because, if you're looking at civil litigation and you're looking at the plaintiff, the person who bought the house adjacent to the farm, further down the road, it's easier to argue to say that, hey, you had noticed when you bought this place that you'd be encountering potentially bad smells and all the other accompanying things. And with that knowledge, you still purchase this property. That's just a thought.
makes sense.
You look eager to say something.
I just want to say that there was a case called Trickus versus Ox in Addison, where it was an apple orchard and people moved in next to, they had been an apple orchard for decades, if not longer. But what they did is they changed their packing operation so that they were packing often at night, which aggravated the new neighbors, and the new neighbors sued. And they won because that change of operation occurred after the new neighbors moved in. So that is one thing that the advocates for this bill are going to look for, some statement that a change of operations is not something that will allow for a nuisance claim to be successful.
Senator Lowski and then Senator.
Yeah, well, and to the same point about the farm disclosure, sort of from the other space, like that is great if that property was a farm, but it's not great if laws change and now a property has started growing cannabis and gotten a bunch of ducks. The neighbors would have no way of having predicted that that would happen. And so I think there's sort of the other, so that change in operation too, I guess it, to me, kind of depends, like, what is that? Is it a reasonable change?
So this bill and in other states, sometimes that type of behavior, it has to qualify. It has to have been in operation for a year before the nuisance claim occurred, and it wasn't a nuisance before that claim occurred. And so there's ways to address those types of situations. So a person could, a neighboring property owner could bring that nuisance claim to address kind of the scenario you're talking about. There's a lot of ways you can go at the right farm, 50 different ways to do it. And it's, you know, there are options. There are options.
Senator Mouse.
So like that change of operation that you're talking about, would that be like, say you had a crop farmer that switches over, I don't know if anyone would, but switches from being a crop farmer to a dairy farm?
That change in cropping, change of and agricultural product, that is one thing that's specifically listed in 6 VSA 4802. When you change over or you change your equipment, say you say this, when it's harvest time, you usually leased out or hired someone to do your corn harvesting. But maybe you buy your own harvester now, and maybe you are on the road with your harvester more often than you used to be. And maybe your harvester is one of the new one is really big and loud, and maybe your neighbors don't like that. And this would protect them.
Okay.
Would it protect me using my new big loud harvester at 3 a.m?
So that would then become whether or not that's a good practice, customary practice.
So maybe.
It may be certain times of the year, you gotta get the crop in.
Yeah.
And they have my window open at night and they're just chopping corn 3, 4 o'clock in the morning. They large farms, they have 24/7 operations. They gotta get it done.
Before winter gets here. Before winter sets in.
And it's really amazing in Franklin County when it is harvest time, because there are trucks on the road constantly. The harvesters are moving constantly. It's like that is part of the culture of that area.
Well, and I guess this gets to my question is what's customary in a heavily agriculture dense area, customary and reasonable in an area that is not heavily agricultural dense, like just because that is customary, it's probably customary in Addison County too, but would be unreasonable, I would think, in downtown Burlington. Even if I have a farm in downtown Burlington, I probably don't have a large farm that needs a 24/7 operation that needs to be running loud equipment at 3 a.m. But it is customary and reasonable. Does my situation matters?
I think that would be something that a court would look at and that the parties would argue.
Okay.
Senator Mouse.
Wouldn't local zoning dictate the activities allowed on the property?
So farming is exempt from consumption.
But even so, like, Just trying to think.
But think about it, the way that
Yeah.
Oregon did it, that Oregon was like, and Oregon's a big zoning state. Like, that's how they try to manage activity out there. They said, if we zoned you, you are protected. And you get a large amount of protection. And so outside of that zone, you don't get that same protection. And in Vermont, that would be a hard thing to do. Because you would have to say that municipalities have they already have ability to designate agricultural zones where they prefer the ag activity to occur, but farms don't have to go there. So, yeah, it's really, so in my work on this, I've talked to the people at Penn State Extension, and they said, well, why don't you just work through zoning? And well, the farming's exempt from zoning. What? No, like to them, that's just so foreign. But to us, that's how it's been.
Oh, now I'm thinking of chickens in neighborhoods.
Well, that's why we got to know,
The 100
that's why you had to, because there was
and the 2000.
situations around the state where people would have, 30 chickens in their backyard and a couple of roosters, and it was loud and it was smelly. And the municipality would come and say, you have to do something about that. And they would say, well, I'm farming. And we would have no authority. And then the municipality would go to the agency of ag and say, are they farming? And the agency of ag would say, no, that's not farming. It's like,
So
that's how you got to the Noah's Ark list and the $2,000 from the ag farms.
So if Tanya lived in Burlington and had 150 chickens in her backyard, it was Tanya's chicken farm.
That would be farming, but then she would be subject to the RAPs. She would have to manage her property in a way that it didn't have water quality violations. And this would be tough on farm to manage its mortality the right way. It like the whole, there's a list of things that they would have to do. And it's hard on a small property. In one way, the Essex duck farmer is admirable because he's pulling it off.
Well, so I appreciate that. But so if I had 30 chickens and roosters and they were making noise, they say, no, you're not farming. So I get 20 ducks. So now I meet the 2,000 and now I am farming. My 30 chickens can stay and annoy the neighborhood. So I could become a farm to protect myself from my annoying chickens. I would never have chickens though, because I'm terrified of chickens, but
That's what the individual in Essex.
I know.
He became a farm, said that he couldn't be zoned. And the board gave him a license. The board gave him a license. And they say that they couldn't deny him based on where he was located. And I'm like, well, maybe you need some criteria that.
No, I know that that's what the person in Essex did, was get ducks so they became a farm.
Right.
Nice. I think, I imagine we're going to get folks on one side of the conversation coming in and saying our farm laws are strong, and then people on the other side coming in and saying that they're weak. Hearing from the council objectively that Vermont is on the weaker side compared to our all the other states.
Where murder is the threshold.
Yeah, well, that being perhaps the strongest. I'm definitely open to working more on this bill and hearing both sides of it and seeing what we can do that is reasonable and provides more protections for farmers.
Could I also give some historical context about why Vermont's law was drafted the way it was? Because when it was first drafted in 1998, It was based off of Iowa's law. And Iowa subsequently had multiple takings claims brought by neighboring properties saying that the Iowa law constituted an unconstitutional taking. The court said yes, and there were like 2, maybe 3 cases where that happened. And so the legislature.
Sorry to interrupt. Can you explain what takings is for the?
It's when a government literally goes onto your property and physically takes it, or a government regulation or law affects the use and enjoyment of your property in a way that should have been compensated. And so that's basically what the neighbors said in Iowa, is that their inability to defend themselves against a nuisance actions or ag activity that was a nuisance wasn't taking it. It reduced their use and enjoyment of the property without compensating them for that. But Iowa's courts have subsequent shocking. They've changed that, and they're saying that no, it's no longer taking. And they have this 3-part test, but it's pretty easy to pass. And they return to a very strong right to farm law in Iowa. But we amended our law in response to the Iowa takings claims, so that there is that presumption that neighbor can always say, hey, there's this noxious interference with my use and enjoyment of my property. So there's less opportunity for a takings claim. That's why we're here, because Iowa. But since we made that decision to follow Iowa basically boomerang back now,
We did not boomerang.
and we did not boomerang.
And that's helpful. Thank you. Any additional comments, questions? Yeah. All right, well, if committee, if you have thoughts on witnesses coming into this, the Kayla, no. And I think we can get someone from the Agency of Agriculture and then take it from there.
Agricultural bill.
Yeah.
Judiciary.
In judiciary.
Yeah.
I love it.
All sorts of things.
Have a good day.
Thank you.